Please be seated. The court is now back in session. The floor is once again given to Kyo Sampon's defense to continue your submission. Please be reminded that you shall respond directly to all the questions and issues raised by the chamber and by the co-prosecutors and the lead co-lawyers. In particular, to the 4 questions, number 6, 7, 8, and 9, so that your responses and submissions will be used as the basis for our order in regards to the effect of the orders by the Supreme Court chamber. You may proceed.
Thank you, Mr. President. Just to pull the threads together, I would like very quickly to recall that with respect to the state of health of the accused, I'm not empowered to come down to any verdict on the health of the others, to whom I wish long life. But with respect to Mr. Kyo Sampon, he feels neither sick nor moribund. I think he has a certain amount of time left to live, and that's why, when you ask the question of if we would prefer a complete but incomplete or partial yet completed trial, we believe that Mr. Kyo Sampon would survive either hypothesis, and that this dilemma, which may be warranted, I'm not saying that it isn't, which may be warranted for other accused, should not be put before Mr. Kyo Sampon to justify a breach of his basic rights. I'm not coming back to this because I've talked about it already. With respect to the question of whether the addition of S21, because now, if we refer to the prosecution's request, it seems to me that we're only talking about the addition of S21 at this juncture. So let me echo and endorse my learned colleague Mr. Koppe's remarks, which I wholly concur with. On question number 6, what will be the position of the Kyo Sampon defense if you do decide to add S21 when it comes to documents to be placed on the case file and witnesses that should be summoned and experts and so forth? Our position is very straightforward. In the past, we said that we did not have any particular witnesses to call with respect to S21. We do nevertheless reserve our right to call back to this courtroom certain witnesses that we have already heard and to request the submission of documents as well. And we will very quickly be informing the chamber of the details of this. On question 7, which concerns the matter of whether it would be wise after a certain preparation time, whether your chamber, composed of the same judges, should immediately move into substantive hearings on the second part of case 002. I think I answered that this morning already. The answer that we give you to that on that is negative. We do not believe that that would be wise, and I explained why this morning. Turning now to question 8. which says that the remaining allegations were not discontinued by your good selves in consequence of the severance order and could be the subject of future trials, which is why you're asking the parties what prejudice might result from the absence of a timetable. I would say it's not so much the absence of a timetable, I might have said this a little forcefully this morning, that matters. What we care about is not the timetable and the meticulous day-by-day accounting that is done. When these questions were referred to in August 2012, the prosecution was talking about 33 days. Now we're talking about 11 days of hearings. I don't know if this takes account of the civil party participation. I don't know if this is simply what the prosecution believes is necessary for the defence to cross-question the witnesses. All of this is a secret pudding that has been cooked in the office of the co-prosecution, and as far as I'm concerned, this is a highly inexact science. And as I see it, what the Supreme Court chamber was criticizing in this series of decisions on severance was not so much the absence of a timetable as much deeper problems. And the way this question is posed, I find a little bit awkward. I can't really answer it without extrapolating, and that is why this morning I did refer to a certain number of points that seem to me of crucial importance and which are breaches of Mr. Kyo Sampan's right to a trial within a reasonable period of time in respect for his fundamental rights. Because the problem of a timetable is procedural housekeeping. What really matters is whether or not the accused know why they are being tried and how they are being tried. Hitherto, although we have been running for a year and a half now, we haven't really known the answer to that question. This leads me straight into question 9. What would the impact be of the annulment by the Supreme Court chamber to the effect to the rights of the accused to a trial within a timely period and to their basic rights? And I did answer that this morning. That's why this morning I did believe that I was actually responding to the questions put by the chamber, and I did say that as I see it, and as far as Mr. Kyo Sampan is concerned, whatever decision you take, his entitlement to a fair trial and a timely one have been violated by today's present circumstances. And whether you decide to have a trial on the entire closing order, although over the last year and a half we have been having hearings already, or whether you decide on a whole series of mini-trials in the interests of justice, or whether you decide on having a single trial that is more representative, but which is a single trial perhaps for the other two co-accused, but which won't be a single trial for Mr. Kyo Sampan. Let's be clear on this, and that's why I don't feel concerned by that choice, which seems to be somewhat abstract. The medical experts who tell us about the state of health of Mr. Kyo Sampan will tell us coming up in the middle of March, but Mr. Kyo Sampan, they will say, is fit to stand trial and is not therefore concerned by the need for expeditiousness, which seems to concern everybody here. This situation could perhaps, let me propose, be compensated for, and I haven't drafted this in very fine detail because time is short, but you could consider a severance in personam. In other words, judging Mr. Khieu Samphan for the entire closing order on his own, which would mean that when the other accused encounter health problems that makes it impossible for them to come to the courtroom, you would be able to concentrate on his trial. And were you to take that decision, I believe that the logic of my proposal applies to what you might call compensation, or let us say, at least, the merits of bringing an end to the maintenance of Mr. Khieu Samphan in detention. We are shortly going to be submitting a request that Mr. Khieu Samphan be placed under house arrest. We do not believe that simply by adding S21, were that to be done, or under the hypothesis that you originally set without including S21, one way or another, we're not out of this for the next 3 or 4 years before we have a final verdict. And it seems to us entirely reasonable that or unreasonable rather, that an 82-year-old should not wait 8 or 9 years for his trial. And so I am announcing now that we are going to be submitting a request for release, which would not change the prejudice my client has undergone, but would allow him at his age to calmly await your verdict. Mr. President, I was going to suggest that I answer the questions put in the additional memo that came out at a later stage, but perhaps I'm jumping the gun here. Thank you, sir.
President, National Council for Khieu Samphan, you may proceed. Council. Thank you, Mr. President. Good afternoon, Mr. President, Your Honours, everyone in and around the courtroom. I would like to supplement to what has been stated by my colleague. I fully support the statement and submissions made by my colleague. The trial chamber's servant's order, as we all know, is no longer valid as it has been annulled by the decision of the SCC. This means that we virtually start the case anew. But why do we have to hold today's proceeding? Per the trial chamber's instruction, this is an attempt to correct the errors made in the severance order, or we can simply say to remedy the severance order which had some mistakes. The proceedings so far seems to made through issues, especially the issues that have an impact on my client, that is Mr. Kieu Sampon. In particular, his right, as stated in the Constitution, that is the presumption of innocence. Many of the learned friends said that the severance order was prejudicial, prejudice. And why is that? When we make a presumption that certain facts will be cherry-picked for trial, and some other facts shall be packed to one side, and that the presumption that the facts that handpicked for trial is already a sign of a presumption that the facts and the guilt of the accused before even the trial started. So the cherry picking of certain facts shall not be done, as it seems to violate the Constitution on the principle of the presumption of innocence. Because such a principle is not applicable before this chamber when certain facts are handpicked for trial. The second point is my client's right to have a fair and expeditious trial as expressed by my colleague. Whatever the trial options selected by the chamber, it will continue to violate my client's right. As Your Honours have noticed and as raised by my international colleague, my client participates almost fully in all the proceedings, and in other cases, he has to wait at the detention center due to the unavailability of the co-accused. We can see that when other co-accused are unavailable, then my client has to be detained in the detention center and he cannot exercise his right of fair trial. And that is a clear violation of his right. We can look at the proposals made by the trial chamber as to whether we shall reuse or remove part of the facts, and we only select some facts which are representative as requested by the co-prosecutors, which is the second option, and as claimed by the co-prosecutors, that is the best option so far. The application of either the first or the second option does not benefit my client in exercising his right. The reason is that it is not up to my client or the proceedings against him alone, but it is the proceedings against all the co-accused. If one approach is used for all the co-accused, in this instance, that approach is not applicable for all the accused. I can, on the one hand, say the application or the approach for my client may not be necessarily applicable for the other co-accused. So we can say circumstances for all the accused are distinct in its own way. If we use one approach or one principle or one application of law for one accused, it might have an impact on the other co-accused. And to respond to the questions put to us by the chamber, that is what I wish to say, as my international counterpart has said sufficiently. But anyhow, I'd like to add some comments. Regarding the first question, as raised by the co-prosecutors regarding the advanced age of the co-accused that requires expeditious trial proceedings, I am of the opinion that the advanced age is not the fault of the co-accused nor of my client. The question is, how come such proceedings have dragged on so far? It means the trial started 38 years after the crimes were allegedly committed. Is it the fault of the accused? The first issue is actually the establishment of this very court to prosecute such crimes. Second, it is the strategy employed by the prosecution regarding the situations of each accused. As I indicated at the outset, the co-prosecutors know very well about the advanced age and the health issue of all the accused. For that reason, they should have factored in all these issues before they make their presentations for the prosecution. And that is their own discretion and choice. President interrupts. Counsel, that points were raised this morning, and what we need from you actually your responses to the questions put to you as a result of the effect of the decisions by the Supreme Court chamber to annul the surveillance order by the trial chamber. In the decision of the Supreme Court chamber, they present two options. One is the entire facts in case 002 shall be tried, and the second option is to advise the trial chamber to reconsider several facts in case 002. pursuant to Internal Rule 89 ter. And that is the instruction from the Supreme Court chamber. And of course, we'd like to get precise responses from you. Whether you would present to us appropriate methods or solutions to these two options presented to us by the Supreme Court chamber. What would be the pro and con for the one whole trial of facts in case 002, or the severing of the facts? And of course, we did that in 002/01 proceeding. And with the submissions to expand the scope in case 002/01, we acknowledged to accept one fact and rejected two facts by the co-prosecutors, which led to the appeal to the Supreme Court chamber. And of course, as a result, we are here today to discuss this very issue. And I sincerely hope that you would take this floor to make your points directly connected to what I just said, in particular connected and related directly to our memorandums, so that the trial chamber would have all the complete picture from all the parties. Counsel, thank you, Mr. President. I am, now responding to the questions raised by the chamber. It is rather convenient for us to respond yes or no, but of course we would like to present a more fuller picture in our response to what has been raised by the co-prosecutors. Allow me to continue, Mr. President. Mr. President, Your Honours, we, the accused Sampon's defense, do not support any option which require the severance in this case, for example, the addition of facts which would violate my client's right. That is the gist of my submission, Mr. President. And the point that I raised, that is the advanced age of the accused, it is not the fault of the accused. It is the point that the prosecution was well familiar from the outset. If they were to think that because they are old, then they should think of the strategy for an expedited proceeding by taking into account the fair trial process and right of all the accused. And it does not mean that we have to jump to only certain facts to be tried because of the advanced age of the accused. That is improper, in my opinion. To respond to the fourth question, and of course I will respond from question number 4, as my international colleague already responded to question 1 to 3. If the trial chamber acknowledge and accept S21 as part of the trial, then we need additional time to prepare ourselves for the debate on that fact, as we need to conduct further research on this very topic. Now I'd like to jump through questions number 6, as question number 5 is excluded. In fact, witnesses have already been proposed. In particular, the witnesses are proposed by the co-prosecutors. In the case where the co-prosecutors would like to present additional documents and witnesses, so do the defense teams. We would need to review once again all those related documents, witnesses and experts, and needs to make a new submission. And to respond to Your Honor's question number 7, it is my opinion that the trial chamber indicates that it is likely, or there is a possibility, that there could be other smaller trials after the conclusion of 002/01. We can only respond to this question only in connection to questions number 9, as what would be the impact on our client and on other co-accused. Here I refer to a fair and expeditious trial. As I indicated from the beginning, my client's presence to follow the proceedings is almost permanent, and of course he lost his opportunity when other co-accused is not available during the trial proceeding. And of course he does not. He has not waived his direct presence to participate in the proceeding. And as a result of the unavailability of other co-accused, my client has to wait. And he has to wait not at his house, but at the detention facility. And that is a clear violation of his right. If the trial chamber reviews once again the proceedings in case 002/01, and if this standard keeps going on for 02/02 or /03, then my client's right is continued to be violated. The trial chamber is competent to provide assurance to other parties that in the likely event there shall be no case 002/02 and 03 and so on and so forth. However, this has to be in agreement with the co-prosecutors that they will not seek another trial segment in case 002/02 or 03 against my client, as the continued detention of my client in this instance has violated his right. So the postponement of the proceedings, of course, has an impact on my client's time, as he should have been with his family. Of course, based on the principle, my client is not guilty as charged, and he is not guilty for any alleged crimes by the co-prosecutors. Once again, I'd like to recap my main point, and as raised by my international counterpart, we seek the release of my client, Mr. Khieu Sampon, that is to release on bail. President, Counsel, it seems that you wander far away from the focus point in this proceeding. If you have other points to raise, please do it in your written submission. The agenda has been clearly stated in both the Memorandum of Understanding and at the beginning of the opening of this proceeding on the morning of the 18th February 2013. And this morning, once again, I reminded all the parties of what needs to be discussed during today's proceeding. Please stick to the instructions as set out by the trial chamber. And if you have any other issues, please do your submission in writing so that it does not confuse people and have an impact on the current proceeding before us. You need to consult all the instructions that we raised in our memorandum. And the sole purpose of that memorandum is to get all the opinions, submissions, and observations by all the parties in this case, so that we can reissue our decision and not to delay the proceedings against your client. This is another reminder to you so that you only respond to the very issues raised for today's proceeding. Counsel, thank you, Mr. President. Of course, what I raised is the violations and the impact on my client's right. That is in response to your questions number 9. President interrupts. I understand that, Counsel, but you also made a submission which is out of the questions for today's proceeding. Please do not do so. Counsel, my apology. Of course, we have a submission to make, and of course, that is the strategy we use to defend our client. President interrupts. I understand your right. However, for the proceeding before us, we determine the agenda and the points to be raised during the proceeding, and please use the time appropriately as instructed. Counsel, thank you, Mr. President. What I have raised so far is the impact on my client, and of course we will make our submission in due course. To summarize my point, that is regarding the impact on my client, I raised 2 points. That is, one, the violations of the principle of the presumption of innocence as stated in the Constitution, and the second point is the violations to the principle of a fair and expeditious trial. My client's rights in these two core themes were not entertained by your severance order, Your Honor. And I appeal to you to review these two principles. President, thank you, Counsel. However, you have not responded to some questions. In questions number 6, we put a question to other parties that in relation to an extension of the scope of case 002/01, still thought, that is the inclusion of S21 and the grave breaches of the Geneva Convention related to Security Center S21. We asked all the parties to indicate how many documents, witnesses, and experts that you may wish to add. As we said this morning, this is one of the elements that the Chamber will use in order to consider the request for extension of scope by the co-prosecutors. Can you kindly respond to this question? In fact, it has been put to other parties long before the trial started. Counsel, yes, Your Honor, we cannot indicate the exact times. It depends on the submissions of the list of documents or witnesses by the co-prosecutors. By then, we will be in a position to respond. President, thank you. In the decision by the Supreme Court Chamber dated 8 February 2013, which gives us two options. One is whether we the trial chamber, shall conduct one full trial for all the facts in case 002, or second option, alternatively, to reconsider the severance order based on the spirit of Internal Rule 89-ter. And I'd like to get your clear position on that. So that we can prepare, or we will be in a better position to look at the remaining facts besides the one included in case 002/01. If I am not mistaken, neither you nor your international counsel has responded to this question, or whether you believe that these two options are not applicable. Please clarify your position. Counsel, thank you, Mr. President. In fact, if we look at the impact on the right of my client, the expeditiousness of the proceeding cannot be guaranteed. The best choice is to sever my client from the trial, I mean from the joint criminal enterprise principle. If we look at the overall facts and proceedings for the entire case, my client does not object to the overall proceedings. However, if there is an inclusion or extension of scope in this case, or in the possible case 002/02 or 03, it will definitely have an impact on my client's right.
The President. Thank you. I hand over to Judge Lavange. You may proceed. Yeah.
Oui, merci, Monsieur.
Thank you, President. I seek some clarifications. I'll be quite brief. We've heard from the defense team for Mr. Kyo Sompong evoke a possibility to release the request to release the client, and that they intend to make such a request at a later stage in time and not officially today. We have also heard a request to have the participation of Mr. Kyo Sompong severed. Are we to understand that such a request is officially being submitted today at these hearings, or at a future stage when your request for provisional release or release on bail will be made, or at the time when the fitness to stand trial will be assessed by the medical experts? Counsel Verken, to answer your last question, Your Honor. We have envisaged all of the possibilities that are being entertained by your Honorable Chamber in order to address the current situation. Is it necessary for us to formalize a request for severance with further reasoning? It is incumbent upon your chamber to decide. We are simply raising the possible consequences stemming from the decision of the Supreme Court chamber and the effects on the current trial. You must also bear in mind that this puts us in an extremely difficult predicament, and this is why I am addressing the matter now. It is difficult to provide counsel to Mr. Kyo Sompong, since to date, or at least up until the moment you will have definitively defined the confines of the scope, we have no overall perspective or knowledge of the facts that Mr. Kyo Sompong is being tried for. And once again, the decision of the Supreme Court chamber exasperates the difficulty because it effectively orders us to begin from scratch and reconsider the entire case. Therefore, it is very difficult for us to weigh the pros and the cons when we are still unaware of exactly what we are dealing with. What the heart of the matter is that the reason why we have invoked such a request is not because we have been able to develop it extensively, but it just demonstrates the extent to which we must call for justice to be done and justice to be properly served. And if following the issuance of a decision and following the assessment of the medical condition of the accused or a possible improvement of their status or their participation in court or through video link, those are entirely within the realm of possibility. But it is a very onerous decision. For the time being, Your Honor, we are simply making a suggestion, a proposal to illustrate to what extent this situation is of the utmost urgency and is extremely difficult. If you believe that such a request must be submitted in a formalized manner, then perhaps it would be well advised to have the doctors make an assessment of his health condition, and it is following the medical reports. And in fact, yesterday you issued a memorandum in which you indicated that there would be fresh medical hearings in mid-March 2013, and I believe that there's still some outstanding issues. But today, as it stands, my national colleague and I are stating that this is certainly a possibility that we envisage.
The President, thank you. Now, I hand over to the co-prosecutors and the lead co-lawyer for the civil parties to reply to the various submissions and observations by the three defense teams. You may proceed.
Thank you, Mr. President. Good afternoon to everybody. There has been a lot said by the three defense teams since this morning. Some of it, I would say, rather new and surprising. But let me start by trying to distill a little their positions, strip away some of the rhetoric, and see where we are in terms of there being a number of issues on which the parties actually agree and where the parties disagree. Starting with where the parties all seem to agree, one issue on which we agree is that the trial chamber should not simply return to the terms of the original severance order. The prosecution, the civil parties, and all three defense teams have expressed that position. It would also appear that the parties are in agreement that the chamber should proceed on the basis that there will be one trial. I say this because the Noon Chea and Ing Suri teams have both requested that you do not do any severance at all. And while the Khieu Samphan's team position is a little fuzzy at times, they have stated that they do not favor any severance. So there seems to be a consensus among the parties that we should proceed at this time on the basis of there being one trial rather than a series of trials. The parties agree, or at least do not dispute, the principle that this one trial needs to be more representative. I add as a caveat to this that the Ing Suri team, Mr. Carnivus, has made an argument to the effect that the trial chamber may just ignore the Supreme Court chamber's decision. But as I will address a little later, we do not view this as an argument that you can seriously consider. And ultimately, Mr. Carnivus suggests, and I'm paraphrasing, that the trial chamber should look to the prosecution for the plan on how to proceed. The disagreement between the parties seems to boil down on what should be included in this one trial, and on how long, and therefore on how long the trial should be. So I will now focus on some of the specific issues that have been raised by each of the teams, particularly in regards to this last point of what should be included in the trial, which is really the most important task that lies with this chamber. Starting with the position of the Nunchea team expressed today. And I must say, it was with some surprise that I heard them, when I heard them stand and state their position now that case 002 should not be severed at all. This could be called the mother of all flip-flops. It was not long ago that the Nunchea defense team made the following statement after the court's severance order. It called it, quote, without a doubt, the most sensible decision to emerge from the ECC, end of quote. That position remained in effect as of when it was brought up last August, and they opposed our appeal. Nonetheless, they have now changed their view. Indeed, so has the Ing Sari team changed its view in asking now that this court try all of the issues of case 002. And counsel himself said he felt rather strange standing up and making this argument. I would concur with that, but I think it is not too difficult to figure out why the defense teams are now taking the position that this chamber should try all of case 002 and not proceed based on the severance that is proposed by our office. One can assume that they have read the Supreme Court Chamber's decision and understand that there has to be some representativeness in this trial, and therefore it would be difficult for them to stand and argue that we should only proceed with forced movement. With that option having been taken away from them and facing a request from us to add S21, perhaps they consider their next best option to create as much chaos as they can, as much delay as they can, and to request a trial that may very well and probably would not be able to be completed while their clients remain fit. That is at least our observations on this rather surprising flip-flop in the defense positions that we have witnessed here today. In regards to some of the arguments that were made by Nunchea's counsel as to the problem of a severed trial, he raises the argument that a limited scope trial prevents them from mounting their defense. We dispute this very much. It is not in any way supported by the record of the proceedings to date. This is the defense team, I would remind everyone, that regularly asks witnesses questions relating to events that occurred after 1979. They have not in any form or fashion been limited from questioning witnesses about matters that had any potential of being relevant to case 002. The argument is made that there was confusion on their part, that they did not know how to proceed questioning witnesses because of the severance. And this is an argument that has been pulled out every now and then by the defense teams. And for that reason, I would like to go back just for a moment and to remind everyone of what this court said at the time the severance order was initially made. First, and I'm referring here to document E-124/7, which was the 18 October 2011 decision of this court on our motion for reconsideration of the severance order. And in paragraph 10, the Chamber indicated that its severance order was motivated by, and it listed a number of items. One of those was, quote, to ensure that the first trial encompasses a thorough examination of the fundamental issues and allegations against all accused, to provide a foundation for a more detailed examination of the remaining charges and factual allegations against the accused in later trials, and later on to, quote, ensure as far as possible that the issues examined in the first trial provide a basis for the consideration of the mode of liability of joint criminal enterprise by including all accused. The trial chamber then stated in the immediate following paragraph, paragraph 11, quote, it follows that the chamber during the early trial segments will give consideration to the roles and responsibilities of the accused in relation to all.
The President. Prosecutor, please be reminded that you should slow down a bit. I have signaled you several times, but you did not pay attention to it.
My apologies, Mr. President. Referring to paragraph 11, let me start again with the quote. Quote, it follows that the chamber during the early trial segments will give consideration to the roles and responsibilities of the accused in relation to all policies relevant to the entire indictment. End of quote. On that same date, the trial chamber issued another order regarding the scheduling of the start of trial. And this is document E-131. And in that order, the chamber made the following statement to all the parties. Quote, as explained in the Chamber's decision of 18 October 2011 E-124/7, and that was the decision that I just quoted from, the reconsideration decision. As explained in that decision, quote, the accused must confront all allegations contained in the indictment in case 002. And while the Chamber's severance order of 22 September 2011 separates proceedings into a series of smaller trials, it is envisioned that the first trial will provide a general foundation for all the charges, including those which will be examined in later trials. End of quote. I go back to these statements to remind everyone as to why the trial proceeded in the fashion that it did. As Mr. Coppi complained that it took a long time to deal with these issues and that this was a surprise to them. In fact, everyone knew that this first trial would proceed in a manner where we would start by building the foundation for all trials. There was a meeting of all parties with the senior legal officer where it was made clear that it would be expected that this phase would require at least a year. And so it is unfair to walk into court now and to complain that they were confused about how to question witnesses. All parties have understood in proceeding here that the witnesses that are being examined on what we call these foundation issues, the policies, how the regime functioned, what the roles of the accused were, and what authority different people and different organizations had, that these were issues that would be used for all Case 2 crimes. Because of that, we are in position now to add additional crimes. We are in position to proceed without the nightmare scenarios that the defense now try to bring to your door. We have always been proceeding on the understanding that the evidence being used in this case applies to all crimes on which the accused are charged. What we submit must happen now is this chamber must decide what additional crimes will be added to this trial. That will not prejudice anyone.
The President. Thank you, Mr. Prosecutor. But the time is now appropriate for the afternoon adjournment. The chamber will adjourn now until 3 o'clock.